Gentlemen, officers, ladies, and to the first of the Northumberland Local Area Council Right-of-Way Subcommittee, which is held physically, I'm very pleased to say, and is not on Zoom or Teams. So can we first of all note the membership and terms of reference, which has been changed unavoidably. Oh, come in, Kathleen. Yes, I've just, sorry, Catherine, I've just started. Sit as you, where you one of these tables. You might as well sit dead in front there, please. Yeah, thanks. You'll have noted that when I was allocating places on the this committee, I inadvertently forgot at the time that there was a difference between Labour and Independents, and that we actually had to give a seat to the Independents and as a formed party. But in fact, they don't want it. Oh, well. They have declined the offer, as has Labour again. They've got one, they were given the option. The answer was no, thank you. So I've gone back to Mark Mather, who has kindly agreed, but today he's on an important course in Scunthorpe, learning how to drive a combine harvester, so isn't with us. So we've got the quorum as shown there. Sorry, not the quorum, the committee as shown there. And I learned today that the quorate is 2, and I was being a wooder, but we are more than quorate today. Thank you, welcome. So you've noted the terms of reference, I hope, of the committee, and I think I'll continue with item 2, apologies for absence. Apologies I will give for Councillor Swinbank, who has had to isolate because of a family member being COVID positive. And I think we have apologies I've just mentioned from Councillor Mather, who is away unavoidably. Is that it? Yes, thank you. Item 3, minutes. The minutes of the Northumberland Local Area Council Rights-of-Way Subcommittee held on 20th of April are circulated to be confirmed as a correct record and signed by the Chair. Councillor Seymour, do you agree it's a correct record?
Yes.
Thank you. And therefore, well, the only 2 of us were at that meeting, so we'll say we'll go ahead and accept there's a correct record. Thank you. Disclosures of members' interests. Are there any disclosures of members' interests? No. No. Thank you. We will then proceed to the item 5. And could I just say, technology is with us today. We've actually got 2 screens, probably after my complaint the last time. I couldn't see this one from sitting up here. But we've got one down there. I find that easier to see as you wish. And I'm going to hand over now to item 5. Are you on your own today?
I am on my own today. David couldn't make it.
Oh, well, it's all yours. The floor is yours on item 5. And off you go.
Right, thank you, Chair. So this first item is alleged byway until traffic number 31, parish of Edlingham. The plan for this one is on page 18 of the report, and I'll go through some slides to start with, just so you can sort of see the route. And this runs from north to south. I suppose it might be helpful to have the plan on page 18 so you can see. So starting, this is effectively going from point L to K through to J. Hope everyone can see. It's a bit far away, really.
Is that a hard surface?
It is now, yes.
Right.
So from Learchild Farm southwards, it becomes a tarmac surface.
Right.
So that's that one. So
as a new member, Colin, if you're struggling with the mapping, I'm sure you're okay, but do ask, because you're okay.
Okay. Can I just ask you to periodically flick that to stop it switching off? Because I'm bound to forget while I'm doing this. Just backwards and forwards occasionally should do it. Thank you. Right, so this route, well, I'll just read the first bit. In this report, the Northumberland Local Area Council Rights-of-Way Subcommittee is asked to consider all relevant evidence gathered in support and in rebuttal of the existence of public vehicular rights over the U3058 road from the A697 road southwest of High Learchild in a general northeasterly and northerly direction to the C90 road east of Jockey's Dyke Bridge. And as I said, it's on page 18, JKL. Now, I'm just going to read this next bit of background once, but it'll apply to all of the different reports. So, but I think it's important to sort of set this context, and also, as I say, I'll read it this first time. So, by virtue of Section 53 of the Wildlife and Countryside Act 1981, the County Council is required to keep the definitive map and statement under continuous review and make modification orders upon the discovery of evidence which shows that the map and statement need to be modified. The relevant statutory provision which applies to adding a public right-of-way to the definitive map and statement based on historical documentary evidence is Section 53(3)(c)(1) of the Wildlife and Countryside Act 1981. This requires the Council, as surveying authority, to modify the definitive map and statement following the discovery by the authority of evidence which, when considered with all other relevant evidence available to them, shows that a right-of-way which is not shown in the map and statement subsists or is reasonably alleged to subsist over the land in the area to which the map relates, being a right-of-way such the land over the right-of-way subsists as a public path, restricted byway, or subject to Section 54A, a byway open to all traffic. And this is probably, I appreciate there's only one new member here today. I was kind of geared up for possibly 3 new members. But this is an important aspect of this, is that for most of the reports you'll be considering, what you're looking at is there a reasonable allegation? It's not, is it 100% certain? It's not even the civil law balance of probabilities test, which we would have to apply for confirmation of an order. At this stage, all we're looking at generally is there a reasonable allegation? Is it reasonably alleged? So it's a lower level test. So just to be sort of, it's an important thing that people often miss out on, but it is an important aspect of it. So,
Perhaps it's worth saying what the process is after this, if you see what I mean. Explain where we are with this. This is not definitive in the sense of this is the final decision, is
No, absolutely not. So what you're being asked to do here is basically assess all of the evidence. So right at the start, I did a consultation exercise and an information gathering exercise and did research to gather the evidence which is in this report. And I'm presenting all of the summation of collating all the evidence into this report and presenting it to you. And then you'll take a view on whether the rights that I'm saying I think exist are reasonably alleged to exist. Now, if you agree that they are reasonably alleged to exist, you'll all vote on it at the end and say, yes, that's correct. That's not the end of the matter, and it doesn't change anything in reality. What that does is you're giving officers authority to then put this route in a definitive map modification order, and that modification order is the legal thing which will amend the definitive map. Now, when we make that order, we have to advertise it by serving notice on the landowners, putting notices on site, serving notice on path user organisations and parish councils and people like that. And then everyone gets a 56-day window within which to object. If there are no objections to the order, then the County Council can itself confirm the order as unopposed. We then have to apply the balance of probability test ourselves. So we might, in very extreme circumstances, decide that even though there were no objections, we're still not convinced that on a balance of probability the rights exist and we're not going to confirm the order. That's unlikely, though. If there are objections, then we have to submit the order and the objections to the Secretary of State for determination, and the Secretary of State appoints an independent inspector who looks at all the evidence that we've considered and any extra evidence which is put into the process as a result of the objections and later discovery of evidence. And then they will take a view based on a balance of probability whether the rights that we've set out in the order exist or not. So, yes, as Councillor Castle quite correctly says, this isn't the end of it. In many ways, this is still just a very early stage in the process, even though obviously a lot of stuff's gone towards gathering this stuff at this stage.
I would like to say it's a very important part of the process, and it's, as you can see, very carefully researched. These papers are extremely well done, as I've always noticed, but it's an important thing, which is why we've got to get this right. And it's a quasi-judicial process in the sense that what we say and how we decide while we've done it can go to court and be discussed. Just be aware of that. A bit like planning.
Yeah.
Thank you.
So, in the late 1980s, the County Council carried out consultations regarding proposals to add a number of unsealed tracks in the north of the county to the definitive map as byways open to all traffic, on the basis that the routes were included in the Council's list of streets as unclassified county roads, UCRs. And the rationale for doing this was so that it would be, some of these routes were not obvious to members of the public, particularly horse riders, walkers and cyclists, that they were legally entitled to use them. So by adding these to the definitive map as byways, it became clear that they did in fact have rights. So it's not, the aim of this isn't to sort of encourage lots of motor vehicles into the countryside, although that may be an effect that motor vehicle users realise that they have rights over these routes too. But the primary driver was to get walkers, horse riders and cyclists aware that these unsealed routes were ones that they could incorporate into their sort of circular walk patterns and things like that. The view held by officers of the council responsible for maintaining the list of streets for the county of Northumberland was, and still is, that only public roads, not public bridleways and public footpaths, were shown on the list of streets. The only exceptions to this were surface paths and alleyways providing pedestrian links between roads in urban areas. Thus, tracks in rural settings which have their own unique reference numbers, such as the U3058, this route that we're talking about today, were considered to be all-purpose public highways maintainable at public expense. The most recent advice from DEFRA, paragraph 4.42 of Rights of Way Circular 109, is that inclusion on the list of streets may provide evidence of vehicular rights, but that this should be examined on a case-by-case basis. In view of this advice, it's considered prudent to evaluate the status of the U3058 unclassified county road based upon more than simply its inclusion on the list of streets. So we're looking at a wider collection of evidence and not just that it's on that list. So when we did the consultation, I got a reply from N. Hargreave at High Child Farm, who confirmed that he and his wife owned from point J to point K, or approximately point K on the plan. And in his view, this route was suitable for vehicles from J to Learchild Cottage, but thereafter it was a rough track suitable for agricultural vehicles only. He did note that the route is often used by off-road enthusiasts who abuse the track and the fields and make a huge mess. The sort of consultation obviously goes to the parish council and path user organisations as well, and the British Horse Society responded to the consultation saying that beyond point K, it's a grass track across fields. There are signs of this section being used by horse riders. From K to J, the route becomes a clear track again, this time being mainly used for agricultural purposes. It will also be used by horse riders as horses are kept at High Learchild. And in their view, this route forms an important part of the local recreational network as it joins another alleged boat at K, which, boat is byway open to all traffic and slipped into technical speak already, which is then joined by a public bridleway, which leads to the minor road near Edlingham. For this reason, the BHS, British Horse Society, supports its addition to the definitive map. Edlingham Parish Council also responded to the consultation, mainly in response to actually a different route, but they added the sort of footnote to their comment saying the parish council would also strongly object to any downgrading of a list of other routes, of which this route was one of those. So then, considering the historical documentary evidence itself, which obviously follows the report, and it may be useful to go through some of the key bits. I don't propose to go through every single bit of evidence, but I'll try and identify some of the more important bits. So on page 24, there's Greenwood's County map from 1828. And this shows that part of the route between the section between Low Learchild and High Learchild is identified, but the bulk of the alleged byway isn't actually shown on that map. On the 1860 Ordnance Survey map, which is page 26, there's, however, clear evidence of an unenclosed track over the route, or predominantly unenclosed. The short section from High Learchild northeastwards is enclosed, but that's, I think, the only section of the whole route that is. And then you might be able to make out just above Low Learchild, which is sort of in the northeast, the top right corner of the map, that the track, there's a little label on the track itself saying 13. If you cross-reference that on the book of reference on page 27, under the township of Learchild, you'll see 13, it says public road. So this is the Ordnance Survey surveys. It has no legal authority in the sense of it's certainly not definitive, but at the time that they surveyed this back in the early 1860s, the Ordnance Survey surveyor believed that this was a public road. Then, if we go to page 29, I've got the North East Railway Deposited Plan from 1881. The railway deposited plans are often a very useful bit of evidence because the railways required an Act of Parliament, and the deposited plans was an important part of that process. They had to do a certain amount of investigation into what the status of the routes that might be impacted by the railway would be. It imposed different liabilities on the railway companies depending on whether the routes were private or public. So they did all generally make a good effort to try and get this information correct. So it is useful information. However, in this case, the two sections of field where the route passes through, which is just north of Low Learchild in the middle of the map, on the book of reference over on page 30, you'll see that it says that both of these sections are field and occupation roads. So at the time of the deposited railway plan, the surveyors plotting the route of that, they came to a different conclusion to the Ordnance Survey surveyor, and basically they identified it as an occupation road. Then the 1899 Ordnance Survey map shows a predominantly unenclosed road over the route. Then the next key bit of information is the Finance Act plan, which is shown on page 32 and 34. This is the Finance Act from 1910, which actually didn't become operable, but it required a whole load of survey work to be done for it, and because it was an Act of Parliament, the survey work was done to a high standard. So sometimes what happens with this is that the key useful bits of information are if a route is an enclosed road, so it's bounded by hedges or walls or something, or ditches on both sides, often the line that the road was on would be excluded from the surrounding land by coloured boundaries. Basically, the land parcels would be identified with coloured boundaries, and the road wouldn't be covered because it was unproductive land. And that's a big clue, a big pointer that if it's separated from the surrounding land by coloured boundaries, that it was considered to be public at that time. This route is largely unenclosed, but what we do have is, which is relatively uncommon, but does happen from time to time, because it's not an enclosed route, it is still nevertheless the surveyor for the Finance Act plans has identified or labelled this route in 3 different locations. It was such a long route, and to avoid it being too small, I've basically split this plan over 3 pages, so 32, 33 and 34 cover the whole route. But on each of those pages, you'll see more or less the middle of each one in red. I hope it's still visible. It says public by road, and then on 34, just above the words High Learchild, public by road. That's probably not quite so clear cut. So again, that identifies that the surveyor to do with the Finance Act returns identified this route as being a public by road at that time, which is very useful evidence in support of vehicular rights. Then the 1923 Ordnance Survey map, which is again split over several to get it in. So it's on 37, 35, 36, 37. You can see that it's a predominantly unenclosed route. That again, it's just really the bit from High Learchild northwards that's enclosed. The rest of it's all generally open or just bounded on one side, which is significant later on. And then the next key bit of information is the plan on page 39, which is the 1932 Alnwick Rural District Council handover map. Now, up until this point, up until 1929, the minor roads in the county were the responsibility of the rural district councils. And under the 29 Act, the responsibility for those was transferred to the county council. So the county council was already responsible for the A and B roads, but effectively, with this bit of legislation, all of the C and U roads were transferred to the county council as well. And as part of that process, effectively the rural district councils had to provide information to the county council saying these are the routes that we've maintained up to now, and here you go, these are now your responsibility. So this handover map from 1932 is effectively the information, a summary of the information that was passed by Alnwick Rural District Council to Northumberland County Council, saying these are the routes that are now yours to look after, that we've looked after previously. And you'll see sort of middle of the plan towards the bottom, so maybe a third up, that there's this route here that is visible as one of the ones. It's sort of the, well, kind of, you might say it's kind of identified, I think, with 39, but it's near the bottom. You can see where it says Learchild. So that route, the whole of the route is basically identified on that plan as being a maintainable highway that Alnwick Rural District Council previously maintained, but now they were passing it over to Northumberland County Council. That's generally, these handover maps are considered to be very important bits of information, and the fact that something's included on it is considered to be very strong evidence in favour of it being a public vehicular right of way. Do that one. Next bit of very strong information is the the plan and schedule produced under the Restriction of Ribbon Development Act, which is page 42. Basically, this was a sort of a planning mechanism to prevent, as it says, uncontrolled development, ribbon development along roads. So again, what the County Council had to do is produce plans and publish these plans, setting out the roads that it had a responsibility, the public roads that it had a maintenance responsibility for, and we're going to protect ribbon development along. And obviously, as you can see, again, sort of in the middle of this route, it's identified as 108. The alleged byway route is clearly identified as one of the routes on that plan, as a road to be protected from ribbon development. So these plans and schedules were produced in the late 1930s. You'll see the schedule was produced in 1937. Next key bit of information is the 1951 highways map, which is on page 45. Again, this is the sort of first that we're aware of proper map that the County Council produced, identifying all of the roads that it had a maintenance responsibility for. And as you can see, the alleged byways shown on there is the U3058 road from from the C90 through to the A697. Then next bit of information is to do with the preparation of the definitive map. So it's on page 46. Now, the definitive map of public rights of way came about after the National Parks and Access to the Countryside Act 1949, and it required the County Council to produce, initially a survey map to identify the routes that it wanted to include, and then it was a three-stage process for getting to the definitive map. You had to produce a draft map first that basically would then have to be advertised, and anyone could challenge what was on the draft map. Then all the corrections were made to take account of the challenges, and then a provisional map was published, and landowners and occupiers got a second chance, no one else, to have a go at whatever was included on the provisional map. And then as a result of all of the challenges that might have arisen as a result of that, when they were concluded, finally a definitive map of public rights of way was produced, and that effectively was the conclusion of the process. So this first map on page 46 is the initial survey document. And you can see basically the route of the alleged byway up until traffic exists on the base map and is coloured brown. Known public roads to assist in the survey process were generally coloured brown to indicate what the extent of the road network was considered to be. And as I say, this one's coloured brown. Then if we go to page 49, this is the draft map, so the first formal legal stage of the process. And you can see that the route from it goes up to the alleged byway route through High Learchild, Low Learchild, and then onwards north, isn't identified on that draft map as a footpath, bridleway, or road used as a public path. So basically, when the survey was being carried out, it was, but you can also crucially see that there are a number of rights of way ending on it. The two paths numbered 1 and number 3 end on the alleged byway route. So the rationale for that would be that if the route itself wasn't identified for inclusion as a footpath, bridleway, or restricted byway, or road use as a public path, but the other routes connecting with it were, obviously people believed that that route must have some rights over it, and those rights must be too high, too important to warrant being included as a footpath, bridleway, or whatever. So the implication being that they thought it was a road, effectively. And then On page 50, the situation hasn't really changed. This is the provisional map, which again shows the same as the draft map. On page 51, we've got the 1957 Ordnance Survey map, which again shows the route in its entirety. Again, you can see that really it's just the High Learchild north-eastwards section, short section that's fully enclosed. The rest of it's either open or just bounded on one side. And then 1962 original definitive map, we can see that on page 53. And again, this is the first version of the definitive map of the county, for the county of Northumberland for this particular area, and you can see that the footpaths 10 and 11 are linking to the alleged byway route, but the byway route itself isn't identified as a public right-of-way. Again, the implication being that it was considered to be a road and not worthy of being included as a footpath, bridleway, or road used as a public path. Then 1964 highways map on page 57. So this is another edition of the sort of council producing maps identifying the roads that it had a maintenance responsibility for. And again, you can see the U3058 right in the middle of the plan. You can see, unfortunately, it went across the join of the map, so I had to sort of patch two together, but you can still clearly see the route. The U3058 in the middle there goes all the way through. On page 59, we have the 1977-82 Ordnance Survey map. You can see where, again, I've had to patch it together because the two sheets were produced at different times. Again, but slightly different here. More of the Learchild Farm bit at the south is now enclosed. So the bit between High Learchild and the main road is now enclosed there. But the rest of the route is predominantly not enclosed on both sides, maybe enclosed on one side, but some of it's completely open, some of it's just enclosed on one side. Then the next, and slightly unusual, most members probably haven't encountered this, I would suggest, before. On page 60, again, a useful bit of information. So without going into too much detail, basically under the Highways Act, under section 31(6) of the Highways Act, a landowner can basically deposit with the county council a set of documents and plans saying, this is the land that I own, these are the public rights of way that I acknowledge to exist over my land, and I deny the existence of any other public rights of way. And if they do that correctly and follow up at the required intervals with declarations reaffirming that position, what that does is prevent the public from acquiring additional rights of way based on otherwise unchallenged use. I should stress it has no impact whatsoever on claims based on historical documentary evidence, but normally if the public trespass for long enough over a bit of land without the landowner ever stopping them or challenging them or taking steps to prevent them, then after 20 years they can say we acquired a right of way. You can actually claim that under a lesser period at common law, but the main one, statutory one, is at 20 years. So what the landowner has done in this case, the Leamington estate, which covered not the bit covered by Mr. Hargreave, but all of the bit from Kay northwards, effectively, in 1997, the Leamington estate said effectively, this is the land we own, these are the public rights of way we acknowledge to exist, and we deny the existence of any others. And you'll see from the plans on page 62 and then their follow-up declaration on 64, coloured in blue, sort of towards the left-hand side of the plan, hopefully you can still see it, the bit that cuts across the now dismantled railway, which you can sort of see cutting through the plan, the map. In blue is clearly identified as a road, is this section of the Ord route. So the Leamington estate is effectively, in 1997, has already acknowledged that this is a vehicular right-of-way. Now, again, that doesn't prove that it's a vehicular right-of-way, but it now makes it very difficult for the landowner to backtrack and say, well, actually, I don't think it's a right-of-way. Even somebody coming forward now, a different landowner, I believe it's the same family own the estate now, but the Leamington estate's still a landowner. So they're kind of bound now, really tied in by the statements they made in 1997. And this doesn't normally crop up very often, or if it does, it's normally often that the landowner's just targeting footpaths and bridleways. So this is a slightly unusual one. They did a better deposit. They identified the roads as well, which a lot of people making these deposits didn't do. And they've clearly identified this route as, to the best of their belief, being a public road at that time. So I carried out a site investigation of this route just literally as lockdown was about to happen last year. So basically from point L on the C90 Garment Edge Bank Road, a 2.5 metre wide, mostly stone surface track within a 4 to 4.1 metre wide corridor proceeds in a southwesterly direction through a field gate set back from the main road for a distance of 160 metres. Thereafter, 2.5 to 2.7 metre wide, mainly tarmac track with a wide grass strip up the middle within a 4.1 to 4.7 metre wide corridor proceeds in a southerly direction basically to the Learchild Crossing Cottage. There's a bit more of a slightly wider section of concrete road thereafter, and then if you remember on, this is problem is, I suppose, that the photographs go in. So this is the concrete road. I know we're now going along the tarmac road there, but grass, and then we leave the concrete road, go through a gate and down, basically through a stone earth grass surface track in a southwesterly direction and then southerly direction to the ford through the Coburn. And if you remember there, there's brilliant, there's the ford. So you see there's not, you can, if you had a tractor or a 4x4, you could probably get through. On a mountain bike, you could probably get through. I had to gingerly go through with just walking boots by stepping on the stepping stones off to the side. But you wouldn't go through in a normal car, you would just get stuck. So that's sort of quite a limiting factor to sort of normal traffic going through there. And then beyond that, you've got a very grassy track. You can maybe just detect some evidence of slightly raised terrace as it goes through there, but it's basically often difficult to define grass track, which is one of the reasons why I think on later ordnance survey maps they didn't pick it up and didn't show it at all. I sent a draft copy of this report to Mr. Hargreave, he being the landowner who commented on the original consultation, responded to the consultation and didn't get any further response from him. Moving on to the sort of discussion phase. When considering an application or proposal for a modification order, Section 32 of the Highways Act provides for any map, plan or history of the locality or other relevant document to be tendered in evidence and such weight to be given to it as considered justified by the circumstances, including the antiquity of the tendered document, the status of the person by whom and the purpose for which it was made or compiled, and the custody in which it has been kept and from which it is produced. And I would also stress at this point, just this once anyway, the representation of a path or track on an ordnance survey map is not evidence that it's a public right of way. It's only indicative of its physical existence at the time of the survey. This is a common thing which crops up. People assume that just because they can see a track marked as FP or BR or whatever on an ordnance survey map, an old ordnance survey map, that it must be a public footpath or a bridleway. That's nonsense. The ordnance survey are just mapping what they physically saw, and when they say FP or BR, it's what they visually or through inquiry ascertained was the type of use that track was getting, a footpath more minimal than a bridleway. But it's not a statement. They weren't required to do any detailed analysis of what public rights existed over it. The route of alleged bioelectoral traffic number 41 is identified on the County Council's current list of streets as being the U3058 road. The route was identified on the Council's 1951 and 1964 highways maps and on the 1958, 64 and 74 county road schedules. The route was identified as a publicly maintainable road on the 1932 handover map and on the map and schedule produced under the Restriction of Urban Development Act 1935. The route has been consistently identified as a mainly unenclosed road track on Ordnance Survey maps since around 1860. The route would not appear to be shown on Armstrong's County Map of 1769, Fryer's County Map of 1820, or on Carey's Map of 1827. But the section between High Learchild and Low Learchild is shown on Greenwood's County Map of 1828. The route was only identified as an occupation road on the 1881 North East Railway Deposited Plan, but was clearly labelled as a public by-road on the plans produced in association with the Finance Act 1910. Section 31(6) of the Highways Act 1980 allows landowners to deposit with the County Council a map and statement and follow this up with a declaration identifying the public rights of way which they acknowledge to exist over the land and denying the existence of any other public rights of way. When made correctly, such deposits will usually prevent the public from acquiring additional public rights of way based on otherwise unchallenged user. That occurs after deposits were made. The landowner's 1997 deposits clearly acknowledge the existence of public vehicular rights over the KL section of the route. The Natural Environment and Rural Communities Act 2006, which is shortened to the NERC Act 2006, had a major impact on the recording of byways open to all traffic based upon historical documentary evidence. Under Section 67 of the Act, any existing but unrecorded public rights of way for mechanically propelled vehicles were extinguished unless one of the saving provisions applied. In brief, these saving provisions were: A, if the main lawful public use between 2001 and 2006 was with motor vehicles; B, if the route was on the list of streets on 2nd of May 2006 and not also on the definitive map as something less than a byway open to all traffic; C, the route was legally created expressly for motor vehicular use; D, the route was deliberately constructed for public motor vehicular use; or E, the vehicular highway came about as a result of unchallenged motor vehicular use before December 1930. Of the saving provisions above, the main one, this will be the one you'll find we'll be applying mostly in these reports, B, will apply to the U3058 road, because where the route is not shown on the definitive map as a footpath, bridleway or restricted byway, and this one wasn't, then the fact that it's shown on the list of streets on the 2nd of May 2006 will be sufficient to prevent the public's motor vehicular rights, assuming those rights existed, from being extinguished. Now, for a route to be a byway open to all traffic, it has to be, one, firstly, a public motor vehicular right of way, and secondly, it has to be a route which is nevertheless used or likely to be used by the public, mainly for the reasons that footpaths and bridleways are used. The southern part of this route, as far as High Learchild, has a drivable tarmac surface and is clearly in regular use by the owners of the farm, the occupiers of the farm cottage, and their visitors. The section between High Learchild and a point just south of the dismantled railway is grass, earth, stone surfaced, and we would not anticipate this section to be driven by normal motor vehicles. The section from the dismantled railway northwards is partially tarmacked with a large grass strip growing up the middle and partly stone surfaced. It would be drivable in a normal car with care, but it does not have the appearance of being part of the ordinary road network. And from the consultation responses, it seems clear that the route is used by pedestrians, horse riders, and by 4x4 vehicles. The relative proportion of these types of public use isn't known, but setting aside the landowner use of the route, use by the general public is considered likely to be predominantly non-motor vehicular. Advice from the Planning Inspectorate in their consistency guidelines states that it is important to have the correct width, where known, recorded in the definitive statement. Now, it's proposed to record this, the enclosed section, the historically enclosed section of the alleged byway route, with a width varying between 7.6 and 9.14 metres that was identified in paragraph 6.2 above. For the remainder of the route, which was historically unenclosed, it's proposed to adopt the council's standard default width of 5 metres, i.e. wide enough for two vehicles travelling in opposite directions to pass each other. Now, I think if you remember going back, the enclosed section of the alleged byway between High Learchild and the A697 road currently appears to vary between 3.9 and 5.5 metres in width, most of it being 4.5 metres wide or slightly less. And the enclosed section of road north of Learchild Crossing Cottage currently varies between 4 and 5.6 metres, with the vast majority being between 4 and 4.7 metres wide. And this long section would only appear to have been fenced off very recently, probably just in the last 2 or 3 years. The short section of road south of Railway Cottage lies slightly wider, for 6.4 metres. It's never, despite the fact that the available width there now is slightly less, we're still proposing to rely on our default width of 5 metres. I don't think we would necessarily chase after the landowner at this stage, but we have alerted them to the fact that it is not quite as wide as we would like, and if they ever came to re-fence that, we would look at refencing it to the sort of minimum 5 metre width. Conclusion. In light of the documentary evidence available, it appears that public vehicular rights have been reasonably alleged to exist over the route of alleged byway up until traffic number 31. The Natural Environment and Rural Communities Act 2006 would not appear to have extinguished the public's motor vehicular rights over the route. The route would appear to satisfy the balance of user character test for being recorded on the definitive map as a byway up until traffic, and it would therefore be appropriate to recognise the public's rights over the route by recording it on the definitive map as a byway open to all traffic. Thank you, Chair.
Well, that's extremely thorough. Thank you very much indeed. What we now normally do is open to members' questions. And the Chair will take the privilege of asking the first one out of personal curiosity, but also a fact I noticed that a good example, 33, the former Cornhill Railway line. There is a proposal, and there's a working group being set up to actually turn that into a greenway.
Oh, right.
From Alnwick up to Bosseyford and beyond. How would this impact on that usage if the landowner, which is the Northumberland Estates, who else, but seems to be in principle supportive, does that have any impact upon?
It shouldn't do. No, it shouldn't. I mean, the whole thing with the greenway is I delved into it a little bit myself. It doesn't seem to give it any formal status. I'm still confused, really, as to who would then be allowed to use this greenway and what protection it gets going forward, whether it can just be withdrawn, whether it's effectively a permissive arrangement that can be withdrawn. So the short answer is I'm not sure, but it shouldn't have any impact whatsoever on this.
Good, that's just interesting. Members, any questions, please, with that thorough presentation? Councillor Thompson.
Very good presentation. So really, it's been a road within living memory. Looking at the maps, and it's only very recently fallen off the OS map list.
Yes, I think that's fair. Yeah. Mm-hmm. I mean, the landowners in this particular case, I think it would be fair to say. Sometimes when we do this for Councillor Hardy's benefit, I suppose some landowners are perfectly happy that their routes are recorded as byways up until traffic. They have no issue with them whatsoever. There are other ones where the landowners are aware that the rights probably exist. They're not thrilled about it, but they're aware. And there are other cases where the landowners are adamant that these rights don't exist at all. And I think, from what you're saying as well, up until fairly recently, these have been on the Ordnance Survey maps. I think it's fairly clear from the Leamington Estates Section 31.6 deposit and from Mr Hargreaves' thing that they're not thrilled about it being used with motor vehicles. They're perfectly happy for pedestrians and walkers, they're the same, cyclists and horse riders to use it. But I think it's reasonable to say that they kind of accept that these rights probably do exist.
If we got a digger and went underneath the portion where it's been grassed over, would there be a metalled surface under there, do you think?
There might be. It's not definite, but there might well be. I mean, the fact that the raised bit is so intact and feels quite firm underneath, there's a good chance you'll find. I mean, not necessarily tarmac, as
some sort of stone.
Yeah, exactly. Yeah.
Thank you. Any other questions from everybody?
No, I'm just intrigued by the process.
Yes.
And
put your microphone on. What you
sorry, I'm intrigued by the process, and it looks to me as if there's been an established path of some description, and it's a fair arguable case that it's continued for a long period of time, and it's something that I would think moving forward should be continued as a right of way.
As a boat, effectively. Any other questions? In which case, I now need a recommendation from members. Looking in front of you, the recommendations are clear from the officers, and I would like a recommendation, please, from a member. Councillor Thompson.
Move the recommendations, please.
Is that seconded?
I'll second that.
Councillor Seymour, that's seconded. Those in favour, please show. That's unanimous. Thank you. Very good.
Excellent.
We'll now move on to the next item, which is very similar.
Yeah. So this is.
And the floor is yours again.
Thank you. So this is alleged byway up until traffic number 32, Parish of Edlingham, and the plan is on page 80. which you'll find is the same plan as the one you were looking at previously, and this one is just looking at the K to M section. I'll try and, I think that first one of necessity had to be quite a long one. I'll try and be more succinct with this one.
Yes, we can compress a lot of that, can't we?
Yeah. In this report, the Northumberland Local Area Council Rights of Way Subcommittee is asked to consider all relevant evidence gathered in support and in rebuttal of the existence of public vehicular rights over part of the U3059 road from the U3058 road northeast of High Learchild in an easterly direction to the C89 road at Hill Head. To date, there's been no landowner evidence on this particular route. On the British Horse Society have identified this route as saying there is nothing to indicate that it forms the start of an unclassified road, so the public will not know that they can use it, which again goes to the argument about why historically we've tried to get some of these routes on the definitive map so that the public are aware that they have rights over it. It has the potential, the British Horse Society say it has the potential to become a useful part of the ridden network once it becomes clear that it carries public rights, and the condition of the route across the field from M is restored. For this reason, the BHS supports its addition to the definitive map. Edlingham Parish Council, again, primarily responding to do with a different route, but then nevertheless still asserting that it would strongly object to any downgrading of these list of other roads, of which this route was one of those routes. Looking at the historical documentary evidence, the route is shown on Armstrong's map on page 82, or it's clear east-west track approximating to the route of it anyway. It's not shown on Friars or Carey's maps, and then there's clear evidence of an east-west route on Greenwood's map on page 86. Sorry, I should stop here where I am before I get any further, because what I have neglected to do is go through my slides. So I shall do that if I may. So this is from K looking eastwards. It goes up that bank ultimately. So there's not really a huge amount of evidence. There's starting to be a little bit of a trace of a kind of raised terrace there, grassed over.
You would call that a track, would you? Have you been there yourself?
I've been there, yes. I think that it has the appearance, if you're looking at it from straight on, you might miss it. You might just appear to be part of the grass field. But there is a definite kind of raised bit of it where it seems to be slightly higher. And then that diminishes. So it's not so obvious from when you get into this next field. And then you get to another ford. This one I wasn't able to wade through. There weren't any handy stepping stones, so basically had to come back round from the other side and attack it from the other end. But then it goes through the ford, up through there, up that bank, past those cows. They might have moved. Continuing, not hugely evident track, but you can just about make it out still. And then it becomes a bit more obvious again. And then this is the bit there. Now, this track, obviously, there's an amount of farm traffic on it to do with farm animals and farm vehicles. But I think this is a thing where enthusiasts, four-wheel drive enthusiasts, like to play on this bit, which is a bone of contention for the owner-occupiers of the land here. And it comes up there, over the bank, and then through this farmyard, and then that's it. So that's basically it. So there's quite a steep element, which, as I say, it does seem to attract some motor vehicles to it. So it's on the clear evidence of a route on the 1860 Ordnance Survey map, which you can see on page 88. There is a label on the route right in the middle. You can maybe just about make it out. It's labelled 29 in the sort of area of woodland below if you look at the I and L of the big Learchild, and then just follow that down a bit, you'll see 29 in the middle of a little track. And then if you follow 29 in the township of Learchild, again it says public road. So the Ordnance Survey surveyor identified that in the 1860s, in his or her opinion, as being a road. Then the route is clear evidence of an unenclosed road track on the 1899 Ordnance Survey map, which you can see on page 91. The Finance Act plan on page 93. The route is, again, entirely unenclosed, so it's not going to be separated from the surrounding land by coloured boundaries, which would have been helpful if it had. There isn't an actually label on the route itself, but you can just about make out below the word, well, so it's got the label Low Learchild, roughly the centre, at the bottom of the plan. It says public by road there in red ink. And that's labelling the route which comes up from the north, well, comes up from the south northwards to meet this track. And obviously, if that was believed to be a public by-road, logically, whatever it connected with must have been believed to be a public by-road as well. I should, in the interest of fairness, point out that the route itself that is labelled public by-road there is in fact on the definitive map as a public bridleway at this moment. So it could be that that labelling wasn't correct, or it's something we have to follow up on, investigate further at some point in the future. On page 94, you've got the 1923 Ordnance Survey map, and again, clear evidence of an unenclosed track over the route. On the 1932 Annagar Rural District Council handover map, which is page 96, you can clearly see this route is identified as a public road where the Rural District Council were transferring maintenance to the County Council. On the Restriction of Ribbon Development Act plan, which is on page 99, similarly, this route is clearly identified as a public road to be protected from ribbon development. The routes identified on the 1951 Highways Act plan, not Highways Act, the 1951 Highways map, that's one produced by the County Council, page 102, that is. So that's the sort of, again, going back the first of the proper highways plans that the Council produced, that we're aware of. The routes identified in brown on the survey map on page, to do with the first preparation of the definitive map on page 103, again, a strong indicator that it was believed to be a public road, and rather than something of lesser status. Then you've got the draft map on page 105, which corresponds very similarly to the provisional map on page 106. And there you've got a public bridleway marked number 2 coming up and just ending on the alleged byway route. And again, it would be very, very unusual to have a cul-de-sac bridleway that just came up and ended on a route, if basically the implication being that that route was deemed to be something not a footpath bridleway that would have also been shown on the draft map. It must have had higher rights, or was certainly believed to have higher rights at that time. 1957 Ordnance Survey map, you can see an unenclosed road or track over the route. On page 109, we've got the original definitive map again, and again, you've got the route itself shown, no public rights of way identified over it. The implication again being because it was believed to be a road, because you've got public bridleway number 9 just ending on the route again, would have been a very unlikely cul-de-sac if the route itself wasn't something of higher status. On page 112, we've got the 1964 highways map, again clearly identifying the route as part of the U3059 road. 1977-1982 Ordnance Survey map, which is on page 114, that's quite significant because at this time, again, the route disappears altogether. So I don't know whether this is just a more ruthless survey in the sense that they culled various things that they'd shown before, or because obviously, as you see from the photos, some of parts of this track were still quite evident when I did it, or whether this is a route that's sort of diminished and then come back again in more recent years. Then page 115 to 119, we've got the landowner deposits under section 31(6) of the Highways Act, the Leamington estate again, and you can see that once again they've acknowledged with the blue lines that this route is a public road, to the best of their knowledge as the landowner. And then on page 122, we've got the council's list of streets on the 2nd of May 2006, which is the very back, which you can again see that this route was included on that crucial document as being a maintainable public highway at that time, on the 2nd of May 2005. 2006, going mad. Right, apologies. So, site investigation just really confirmed what you saw in the pictures, that there was sort of some evidence of a grassy track and then giving way to a stony grassy track. Nothing with any real hard surface down. In summary of the evidence, the route of the alleged byway up till traffic number 32 is identified on the County Council's current list of streets as being part of the U3059 road. The route was identified on Council's 1951-64 highways maps and on the 1958, 64 and 74 county road schedules. The The route was identified on the 1932 handover map and on the map and schedule produced under the Restriction of Urban Development Act 1935. The route was consistently identified as an unenclosed road track on Ordnance Survey maps between 1860 and 1957. The route would appear to be shown on Armstrong's and Greenwood's maps of 1769 and 1828, though not on Fryer's county map of 1820 or on Carey's map of 1827. Although the route itself is not identified as a public by-road, a route proceeding southwards from it is so labelled, implying that at least part, if not all, of the alleged by-way route was considered to be the same. So kind of covered already the bit to do with Section 31(6) of the Highways Act and what the Leamington Estate acknowledged, so I won't repeat that. Of the saving provisions for the NERC Act, the main one, B, which is where routes was shown on the list of streets on 2nd of May 2006, but not on the definitive map as something less than a bioelectrical traffic, will apply to this portion of the U3059 road. So we think basically any motor vehicle rights that did exist were protected from extinguishment by NERC by virtue of it being on the list of streets at that date. Again, for a route to be a bioelectrical traffic, it has to be a motor vehicle right of way first and foremost, and then it also has to be a route that's nevertheless used or likely to be used by the public, mainly for the reasons footpaths and bridleways are used. This route is primarily a grass earth track which could not be driven along by normal vehicles, and the forward crossing of the Coburn could not be negotiated by normal vehicles either. The character of the way is such that looking at it, few people would identify it as part of the ordinary road network. From the consultation responses, it seems clear that the route is used by pedestrians, horse riders and by 4x4 vehicles. The relative proportion of these types of public use isn't known, but setting aside landowner use of the route, use by the general public is considered likely to be predominantly non-motor vehicular. And again, advice from the planning inspector in their consistency guidelines states that it's important to have the correct width where known recorded in the definitive statement. Where no width can be determined by documentary means, such as an enclosure award or highway order or dedication document, there is usually a boundary-to-boundary presumption for public highways. Where there's no evidence of physical boundaries, the council has adopted a standard default width of 5 metres, i.e. wide enough for two vehicles travelling in opposite directions to pass each other. And in the absence of any other evidence, we propose to adopt the standard default 5 metre width. In light of the documentary evidence available, it appears that public vehicular rights have been reasonably alleged to exist over the route of byway up until traffic number 32. The Natural Environment and Rural Communities Act 2006 would not appear to have extinguished the public's motor vehicular rights over the route, and the route would appear to satisfy the balance of user character test of being recorded on the definitive map as a byway up until traffic, and it would be therefore appropriate to recognise the public's rights over this route by recording it on the definitive map as a byway open to all traffic. Thank you, Chair. Oh, no.
Thank you very much. That was a good rattle through, but we have followed that. And I think the next point is to ask, are there any members' questions of this specific item? You can see that Alex isn't just a desk officer. If you can't get him, he's out in the field, plodding through forwards or trying to. Councillor Sebo.
Thank you, Chair. And thank you for this report. Very thorough. I just have a couple of questions. On page 122, it mentions the Roman fort near the dismantled railway. Just I'm lost where the path was. But is that close to that?
It is, yes. So the blue line that's immediately to the west of that is the alleged byway route, yes.
Right. So that's.
It's close to a Roman road.
Any other information on that the site of the Roman fort there or not?
I'm not aware of it. I didn't spot anything obvious when I went past, so I think it could very much be a sort of an archaeology thing, or there's maybe faint lines in the ground on a dry day sort of thing. But I didn't go over to it because it was fenced off from the road, so I couldn't comment.
I'm pretty sure there's nothing there. There's a castle at Edlingham, and that's a lot. I think fine.
All right. The other thing is the Edlingham Parish Council and the objected to this decision. So I'm not sure why they were objecting.
Would you like to?
Yeah, they didn't object to this decision. What they were doing, their response to this consultation was a sort of belated one, particularly dealing with two routes in Edlingham Village itself that they were concerned we were trying to downgrade. So in their sort of late response regarding those two routes in the village itself, they sort of said we don't want, these routes shouldn't be downgraded, and we don't want any of the other ones that you consulted us on in February 2008 to be downgraded either. So that's their thing. They're basically saying they don't want any consideration of the route that we're talking about now to be downgraded, but their objection, or that why they were responding at all, was relating to two different routes altogether.
All right,
Thank you.
thank you.
Any other questions? In that case, you see the recommendations on page 1, 2, 3. Am I right? No, that's not. No, that's not one. That's the next one. The recommendations are on page 69. May I have a proposal from Councillor Seymour?
Happy to recommend
Is that-
the officer's
Thank you.
recommendation.
Is that seconded? Thank you. That's seconded. Those in favour? That's unanimous. Thank you, Alex.
My computer, sorry, I've allowed it to go to sleep by forgetting
Oh,
to
I
click, so-
know what it feels like, but all yours. And we now move on to the next item, item 7 on page 123, when Alex has sorted his kit out. Good man. Right, the floor's yours on this one.
Thank you very much. So this is alleged by Whitmore Traffic number 32, Parish of Newton on the Moor. In this report, the Northumberland Local Area Council Rights of Way Subcommittee is asked to consider all the relevant evidence gathered in support and in rebuttal of the existence of public vehicular rights over the U3096 road from the C106 Alnwick Fords Road north of Overgrass in a northwesterly direction to Glantley's Farm. And the map for this one's on page 136, and the route we're looking at is MNPQ. I'll go through the slides first. This is looking at the route from south to north.
Sorry.
So this one has the appearance of being a bit more road-like, but I think that notice at the bottom is maybe significant. I think that's one maybe the BHS alludes to. But it's not a very great, it's not the greatest of roads. Go through a gate into sort of more of a farmyard area here. Now, I'll stop at this point because this is significant, certainly later. So up until now, the route isn't recorded on the definitive map at all, but from this point onwards, looking northwards from here, this is part of existing footpath number 2 on the definitive map. And this is still part of footpath number 2. And then from this point onwards, footpath 2 is ended on public bridleway number 1, and what we're now looking at is part of bridleway number 1, but it's also part of the alleged byway route. It's still bridleway number 1. And then I think these curbstones possibly indicate the extent of where people think they're maintaining up to. So that would probably be around about point Q, although possibly Q should be slightly further north of there. But anyway, that's the little curbstones, which you can see the line straight across the middle of the road. That's, I suspect, what the boundary is, or the believed boundary is, between the landowner's maintenance responsibility and the county council's maintenance responsibility. So, can I, before I forget, hand you that to do it this time.
The map is page 136, right?
136, yes, for the map. So, again, not wanting to repeat too much of myself, but this is broadly the same as the previous two, but it has two notable differences, which I'll sort of spell out now. So part of the route, as I've said already, is recorded as public footpath, and part of it's recorded as part of a public bridleway. That has a bearing on the tests that need to be applied, because normally what I'm asking you to do is consider whether the rights have just been reasonably alleged to exist. But because these, admittedly, it's just the two short sections, looking at the plan again on 136, what we're talking about is the N to P section is existing footpath 2, and the P to Q section is part of bridleway 1. So those bits, for that northern end of it, we need to apply the balance of probability test. We can't just look at it on a reasonably alleged basis. And then the other key difference with this one, which is moderately common but not usual, is we have a landowner dedication for the public highway rights section. So, well, for the whole public highway rights over the whole MNPQ section, the whole route effectively. So that's a sort of slightly unusual factor there. So to date, we have no landowner evidence has been received, so the consultation didn't get anything from the landowner. Cycling UK did not make any comments in relation to this particular proposal, but they did make comments regarding the existing bridleway, the continuation of this route, by suggesting that it might be advantageous to consider a diversion of that. And I'll come again, well, that applies partly at this section, but also the next route we consider, this is applicable to that one too. Susan Rogers, on behalf of the British Horse Society, responded and said, beyond the farm, it links to 2 public bridleways and so forms part of the recreational network. At M, there is a sign, farm vehicles only, which suggests that it is private access road to the farm. So it's important that it is recorded on the definitive map so the public are not prevented from using the rights of way to which it leads. For this reason, the BHS supports its addition to the definitive map. And this is a thing which crops up, again, it's not very common, but it crops up from time to time. And I think it's sort of landowners, farmers not wanting to get people lost, go up dead-end routes so that they drive up and only have to difficulty turning around and come back. And the signs, when they're saying private road, they're probably targeted against public vehicles, but obviously horse riders, cyclists and walkers might be deterred from those signs as well. Right. Yeah.
Just, what's a restricted byway?
So you've got 4 different types of rights of way. You've got a public footpath where you've got a right of way on foot, public bridleway, you've got a right of way on foot, horseback and with pedal cycle. Restricted byway, you've got all of those previous rights, and you can also take a horse and cart or a tricycle. You can't use either of those on a bridleway, or don't have lawful authority to use either of those on a bridleway, but you can on a restricted byway. And then a byway control traffic is anything can use it. There is a difference also in terms of cycle use. One of the key differences for cycle use, and one of the reasons why sometimes people will make applications to have something that's a bridleway recorded as a restricted byway, because on the face of it you think it won't make very much difference because there aren't that many horse and carts and there aren't that many tricycles around. But if on a bridleway, bicycle is allowed to use it, but they just have to take it pretty much as they find it. As long as the bridleway is in a condition that's suitable for horses, cyclists just have to make do. If a route's a restricted byway, then a cyclist can have reasonable expectations that the route will be better and more easy for them to proceed along. And possibly they could reasonably say, well, I shouldn't have to have a super mountain bike to use it either. If I had just a normal touring bike, I should be able to use a restricted byway.
Thank you.
So going through the map evidence, doesn't appear to be on Armstrong's map, but the route is shown, clear evidence of a road or track on Fryer's map, which is you can see on page 139. Also evidence of a track on Carey's on page 141, and clear evidence of a road or track on Greenwood's map on page 143. Bearing in mind that later on we're going to say that we don't think this route was a road at this particular point, this is something to bear in mind, that there are a small number of routes which aren't public roads or aren't believed to be public roads, which do nevertheless appear on these county maps. On page 145, you can see the Ordnance Survey map from the 1860s, clear evidence of an enclosed road or track over the route then. On page 146, clear evidence of an enclosed road or track over the route of it in the 1899. Then we've got the Finance Act 1910 plan. The route isn't identified or with coloured boundaries, nor is it labelled as a public by-road. So this again, if there had been those things, they would be a clear indicator of public vehicular rights. The fact that it isn't is suggestive of a sort of opposite position. That it wasn't considered to be a public vehicular right of way at that time. Then on 148, we've got the 1923 Ordnance Survey map, which again, you can see there's an enclosed road over the route. 1932 handover map on page 149. The route's not identified as being a one that the Alnwick Rural District Council was maintaining and handing over responsibility for. So just to be clear, not. Then on the 1951 highways map on page, 152, you've got the restriction ribbon development, which again, as I said, would be useful evidence, very significant evidence if the route was identified on that, and it's not identified on that. So in the 1930s, this route wasn't identified as one of the ones that needed to be protected from ribbon development, again, presumptively because it wasn't considered to be a public vehicular right-of-way at that time. But the 1951 highways map on page 153, you'll see the route is shown on that. Now, the thing there is, although it's coloured and is labelled as the U3096, the number that the road number is written in is purple. Now, you'll see if you look at the other routes, all the other U road routes there, the labelling is in black, which what this strongly suggests to me is that the U3096 was a later addition. So when the 1951 highways map came out, or was first issued in 1951, this route wasn't shown on that. And this was amended later on, because these were working maps that the highway staff were using to determine which routes they needed to maintain. So basically this one was penned on as a later addition for reasons that will become clear in a moment. So in 1951, we've got the Bridges and Roads Committee minutes from 24th of September and 17th of December. And what they indicate was basically the landowner, or somebody presumptively the landowner, had approached the county council and said, I have this road, I'd like the county council to take over maintenance responsibility for this road, please. And it was referred to the Private Streetworks Subcommittee for inspection and report, and they reported back and said, basically, it wasn't a terrible road, but if subject to it being brought up to a better standard than it is now, the recommendation was that the route should be taken over as a public road. Then we've got 1952, on page 156, the definitive map, original survey map. So at this point, the route wasn't identified as a public road. Obviously, the 1951 was just the council talking about taking it on, but hadn't done anything at this stage. So the route's basically, I'd coloured, not identified for inclusion. What was, sorry, not identified as a public path. And then the draft map on page 159 is clearer on the point. You can see that you've got public footpath number 2 over a small part of it, the route at Glantlees, and then you've got public bridleway number 1, the green line heading northwest from Glantlees. That's the position that it exists now. And then we've got the 1951, no, we've got the 1954 on page 160, we've got the actual highway dedication plan or agreement. So this is where the landowner is actually doing the dedication, signing the route over, saying, I dedicate this as a public highway. You may not be able to make it out, but at the bottom of the very penultimate line of this sort of little paragraph in the bottom left, you might be able to make out the number 20. What that is basically the route being dedicated is 20 feet in width. So this is significant later, so we've got a clear, this is relatively unusual because normally they just show a red line on the plan saying this is what we dedicate, but here they've actually stipulated a width of the highway being dedicated. 1961, you've got the provisional map again, so this is presumably because the dedication was sort of taking place at around the same time that the provisional map was being prepared, so the provisional map doesn't take any account of this dedication going on in April 1954. So it still shows the north end of the route as being part of footpath 2 and the very northern end as being part of bridleway number 1. The route is, if we go on to page 163, we've got the, which I haven't normally referred to before, but we've got the 1958 county road schedule, and the reason I've got this one is because if at the bottom of the page you'll see Glantlees Farm Road. So this is the first time that this route hasn't been added as a sort of as an afterthought. It's been clearly identified as part of the normal 1958 schedule as one of the routes that the council acknowledges has a maintenance responsibility for. So clearly the road side of the council was acknowledging by 58 that this was a road that they had responsibility for. 1962, the definitive map though, This still shows the north end of the route as being part of footpath 2 and part of bridleway 1. Crucial thing to be aware of here is that once it's started, we're effectively locked into a process, and unless those rights are actually extinguished by something, it becomes very difficult for the council to when in preparing the definitive map, to backtrack and take off the footpath bridleway bit. So I think probably at this point they realised that there was this particular section of the route had been kind of overtaken by events with the road dedication, but they couldn't not show it as a footpath bridleway because those bits had already satisfactorily got through the draft and provisional map stages, which is why we're kind of left with the problem we've got now. So you've got the 1964 highways map on page 167, again clearly shows the route, the Glantleys Road, U3096 in the middle of that plan. And then if you look at the modern list of streets on page 174, you'll see most of the route is recorded on that plan. But again, this is a significant thing. For reasons unknown, the NPQ section was not at that time identified as part of the U3096 road. It is now, that correction has been made, but crucially on the 2nd of May 2006, probably just human error, the bit north going past to where that Glantleys says, which is Glantleys Cottage, that bit was missing. And that might have been potentially fatal to the existence of motor vehicular rights over that section, but I'm going to argue that one of the other saving provisions applied. Right, so basically from the site investigation, you've seen the sort of the photos anyway. It's mainly a 2.7 metre tarmac road going up in a sort of variable 5.5 to 7.6 metre wide corridor for about 800 metres or there, and a little bit more to the farm. And then again, a little bit of a variable width road, slightly less good quality, up to Glantleys Cottage, where you're going over the bit that's existing footpath and bridleway. So I think about the most northerly 85 metres of the route is also footpath and bridleway on the definitive map at the moment. So the route of alleged biometrical traffic number 32 is identified on the County Council's current list of streets as being the U3096 road. The route was identified on the 1951 and 64 highways maps, though seemingly as a later addition on the 51 map, and on the 58, 64 and 74 county road schedules. The route was not identified as publicly maintainable on the 1932 handover map, nor was it on the map and schedule produced under the Restriction of Urban Development Act 1935. The route has been consistently identified as a mainly enclosed road track on Ordnance Survey maps since around 1860, and the route would not appear to be shown on Armstrong's county map of 1769, but is shown on Friars and Greenwood's county maps of 1820 and 1828, and on Carey's map of 1827. The route is not separated from the surrounding land by coloured boundaries or labelled as public by-road on the plans produced in association with the Finance Act 1910. The Council's highways and public rights-of-way records indicate that during the 1930s, 40s and early 50s, no public highway rights were thought to exist over the NM section of the route, and that the NP section was part of a public footpath and the PQ section was part of a public bridleway. Then in April 1954, it would appear that the owner of the land, Francis Nathaniel Heron Widrington, dedicated a public highway over the MNPQ route. Unfortunately, the dedication document does not specify precisely what public highway rights are being dedicated. Those highway rights need not necessarily be vehicular ones. Public footpaths and public bridleways are also highways. It's a thing that often gets overlooked. People just you throw away around the term highway and assume that must be vehicular, but it's not the case. There are several reasons why it could reasonably be argued that the landowner's actual intention was to dedicate a public vehicular highway. Firstly, persons unfamiliar with highway law are unlikely to be aware that, sadly there's a lot of highway officers that fall into this category, are unlikely to be aware that public footpaths and bridleways are public highways. The term highway in everyday usage is generally used to refer to a vehicular route. Secondly, given the width of the highway being dedicated, 20 foot or 6.1 metres, it seems unlikely that the landowner was dedicating something less than a public vehicular right-of-way. Thirdly, since the northern NP part of the route was already a recognised publicly maintainable public bridleway, there would be no need for the landowners to dedicate public bridleway rights over this section. Of the saving provisions for the NERC Act 2006, B will apply to the main MN part of the route of alleged byway number 32. The public's motor vehicular rights would not be extinguished by the NERC Act because it was on the listed streets at the appointed time and not on the definitive map as a footpath or bridleway. Where, however, a route is shown on the definitive map as a footpath or bridleway, then the fact that it is shown on the listed streets will not be sufficient to prevent the public's motor vehicular rights from being extinguished. This applies to the NPQ section of the route. So here it is necessary to see whether one or more of the other saving provisions might apply. So unfortunately, I'm going to have to go through this in a bit more detail than is necessarily pleasant, but it's necessary. Under section 67(2)(c) of the NERC Act 2006, the public's motor vehicular rights would not be extinguished if those rights had been created on terms that expressly provided for a right-of-way for mechanically propelled vehicles. As discussed in paragraph 7.8 above, although it is reasonably clear that the 1954 highway dedication intended to create a public right-of-way for mechanically propelled vehicles, it did not do so in express terms, so this saving provision would seem unlikely to apply. The inspector who determined definitive map modification order number 23, 2012 at Killam certainly took that view. Under section 67(2)(a) of the NERC Act, the public's motor vehicular rights would not be extinguished if they are over a way whose main lawful use by the public during the period of 5 years between the 2nd of May 2001 and 2nd of May 2006 was with mechanically propelled vehicles. The difficulty here is that the Council has no real evidence regarding the balance of user during that 5-year period. So we don't think that one can be used. Under section 67(2)(e) of the NERC Act, the public's motor vehicular rights would not be extinguished if they were over a way that had been in long use by mechanically propelled vehicles before 1930, when it first became an offence to drive off-road. There is no evidence of long-standing public motor vehicular use before 1930 in this instance. Finally, under section 67(2)(d) of the NERC Act, the public's motor vehicular rights would not be extinguished if they are over a way that has been created by construction of a road intended to be used by motor vehicles. The inspector who determined the definitive map modification on number 23, 2012 at Killam concluded that public motor vehicular rights had been saved over that route in part by virtue of this exemption. At Killam, there was the highway dedication by the landowner in 1968, similar to the highway dedication by the MNPQ route by Mr Widrington in 1954, supported by earlier Council's Bridges and Roads Committee minutes stating that subject to the roads being completed to the satisfaction of the county surveyor, they be taken over as highways repairable by the inhabitants at large, and the necessary notices be signed by the clerk of the council and fixed therein pursuant to section 19 of the Private Street Works Act. On that basis, the inspector argued that because the committee decision to accept dedication was contingent upon the road being made up to a satisfactory standard, this meant the road, which must have been unsatisfactory at that time, was to be constructed to a standard suitable for motor vehicles and all other traffic. The minutes relating to the Glantley's Road are phrased in a very similar way to the Killam route, suggesting that this saving provision will apply to the NPQ part of alleged byway number 32. For a byway until traffic, it has to be, first of all, a public motor vehicular right-of-way. I would argue the evidence has indicated that. And it also has to be a route that is nevertheless used or like to be used by the public, mainly for the reasons which footpaths and bridleways are used. Although this route has a drivable tarmac surface and is clearly in regular use by the owners of the farm and the occupiers of the 2 farm cottages and their visitors, it is not a through route for the public. Its northerly continuation beyond Kew is also drivable, but is initially only a public bridleway, then a route with no public status whatsoever. The NPQ section is likely to be reasonably well used by walkers, horse riders and cyclists using existing bridleway 1 and footpath 2. Since the evidence appears to show that the NP section is a public vehicular highway, no longer just a public footpath, it would be helpful for everybody if the definitive map accurately reflected its true status. Since the evidence appears to show that the PQ section is also a public vehicular highway, no longer just a public bridleway, it would also be helpful for everybody if the definitive map accurately reflected its true status too. Many tracks leading up to private farms are private roads with no recognised public rights over them whatsoever, as indeed this route was until the 1954 dedication. This route is not one which is obviously part of the ordinary road network. And the current balance of user isn't known, but based on all of that, we'd say that the character of the route and the type of user that it's likely to be getting, it will satisfy the criteria. The most northerly 205 metres of the route of the U3096 road, alleged byway number 2, is recorded as parts of public bridleway and footpath number 2. At present, there is no mechanism available for removing these parts of the bridleway and footpath from the definitive map on the basis of higher rights to come into being. The only two options we have appear to be to either do nothing, so that the definitive map confusingly misrepresents the public rights which exist, basically under-records them, or 2, upgrade this part now to show that it's a byway open to all traffic. And what I'm going to argue is, what I would argue is it's better to accurately show the rights that exist. That's more important. In April 1954, the dedication document signed by the landowner clearly stated the width of the public highway was to be 20 feet, i.e. 6.1 metres. This largely corresponds with the width that's available now. It's proposed that byway number 32 be identified with a width of 6.1 metres in line with the 1954 highway dedication. Then in conclusion, in the light of the documentary evidence available, it appears that public vehicular rights have been reasonably alleged to exist over the MN part of the route of alleged byway open to all traffic number 32. Then applying the higher balance of probabilities test, we think that similarly those rights have been shown to exist over the NPQ section. The Natural Environment and Rural Communities Act 2006 would not appear to have extinguished the public's motor vehicular rights over any part of the route, and the route would appear to satisfy the balance of user character test for being recorded on the definitive map as a byway open to all traffic, and it would be therefore appropriate to recognise the public's rights over the route by recording it on the definitive map as a byway open to all traffic. Thank you.
Thank you very much. Thank you very much, Alex. Yes, that was a very thorough. Glantleys, I know Glantleys. I know where it is. I didn't realise there was that problem. But we have everyone. Any questions for from any member, please? There are no questions. Do we have a recommendation?
Yes, I recommend that we...
You're proposing
Yes.
the recommendation as shown,
Yes.
1, 2, 3 and 4.
I'll second that.
Is that seconded? Thank you. Those in favour, please raise your hands. That's unanimous. Very straightforward, but I understand how comprehensive it had to be. And we have to get the facts right, and I think they've been got very right.
Well,
A very good recommendation.
Oh, thank you. I was conscious of that you're getting with only 4 reports, but there's kind of the first 2 are kind of almost like bread and butter. They're the standard ones. The third one we just did had various elements which are slightly unusual, but we needed to cover it in a bit more detail. This next one is again a slightly different one. Sorry.
Yeah, go ahead. Thank you.
So this is alleged public bridleway number 5, parish of Long Framlington. And we go on this route east to west. So in this report, you're asked to consider all relevant evidence in support and rebuttal of the existence of public bridleway rights over existing public footpath number 5 in the parish of Long Framlington, from bridleway number 1 in the parish of Newton on the Moor, northeast of Snook Bank, to bridleway number 25 in the parish of Edlingham, northwest of Snook Bank. And the plan for this one is on page 185, and you're looking at the H to G route.
Okay.
So these photos will be taken from H working towards G.
Right.
So this is H. So in this concrete road, if you look east of H, you'll see that's Glantleys. So we ended neatly on that bridleway 1, just northwest of Glantleys, and now we've taken a shift 800 metres or so further to the west. The concrete road that continued beyond Glantleys is this concrete road, and it goes to Snook Bank, and so we're heading along that initially to that gate. So that gate is almost at Snook Bank. It's where the route does a right angle bend. Now, when I went there, I talked to the chap at Snook Bank. He was minding the house for his daughter, so he may have not known better. But basically, he said, oh no, the path goes up on this side of the gate and wall. So I trooped up there. Slight misgivings, because I thought it went through, but the plan I had with me at the time wasn't great. But that does have a bearing on the photos that I'm about to show you. So, but in reality, the existing footpath goes through that gate and then swings in an immediate right, sort of following the other side of that wall. So I'm photographing up the wrong side of the wall, but you can possibly just about make out on the wrong side of the wall, there's a load of pens across the track between the wall and the farm buildings. And then there's kind of, I think, a silage area beyond that. So it would be tricky to get through, which is probably why the chap who was there said, oh no, all the walkers just follow that side of the fence instead, and then go up further and then cut through. So I'm now back on the right route. So this is sort of where that first crossbar dash is at Snook Bank, the field boundary that kind of runs sort of left to right. Looking across, so that the route goes, the existing footpath 5 goes across this bit of moorland. It's not, in a lot of places, not terribly evident that it's there. You can just about make out parts of it. There are various other paths as well. I suspect there'll be some people travelling along this route, but it could just easily be animal tracks too. The animals seem to know they were going. So where that little dip is on the horizon in the woodland, that's the point we're aiming for. So you can still kind of see sometimes evidence of a track across the moorland. Other times it's not so obvious. And it eventually come through to this bridleway gate there, and that's point G. Probably won't do now, but I'll give you that. Thank you. So this one's slightly different. As I say, it's not based on sort of historical highway roads side of records. But here it goes back to, again, the relevant statutory provision which applies when upgrading an existing public right-of-way to one of a higher status based on historical documentary evidence is section 53C(2) of the Wildlife and Countryside Act 1981. This requires the County Council as surveying authority to modify the definitive map and statement following discovery by the authority of evidence which shows, when considered with all other relevant evidence available to them, that a highway shown on the map statement is a highway of a particular description ought to be shown there as a highway of a different description. So the key thing here is it's not the reasonably alleged test this time, it's the higher balance of probabilities test that we need to apply. The route of alleged public bridleway number 5 was identified as public footpath number 5 when the original definitive map of public rights of way was first published in 1962. Its starting point, point G, was described as being the junction with footpath number 4 and bridleway number 16 in the parish of Edlingham. Its end point was given as bridleway number 1 in the parish of Newton-on-the-Moor. The situation remained unchanged when the definitive map as a whole was reviewed during the 1960s, relevant date 1st of November 1963. Then, for administrative reasons, in 2005, part of bridleway number 16 in the parish of Edlingham was renumbered as a separate path, bridleway number 25. That kind of messes around with some of the definitive statements and what's shown on some of the plans. The above arrangement means that at its eastern end, existing public bridleway number 25, parish of Edlingham, is a cul-de-sac bridleway terminating on 2 public footpaths, and that its western end, existing public bridleway number 1 in the parish of Newton-on-the-Moor, is also a bridleway cul-de-sac terminating on a public footpath. The points where these 2 bridleways end is the Long Framlington parish boundary, which was also the former Rothbury Rural District and Rural District boundary. To date, no landowner evidence has been submitted. Cycling UK responded to the consultation, saying adding, well, or I suppose resolving this anomalous gap in the bridleway network is most welcome. They also suggest an alternative route for the bridleway, not exactly following the existing footpath, which has some advantages, certainly for cyclists, might be less good for other people, so we can't immediately pursue it, but it's maybe something to explore anyway. The British Horse Society responded, saying this is an obvious missing link between 2 public bridleways, the likely result of an error made in the 1950s during the drafting of the definitive map. The route is suitable for use by horses, and there is a bridle gate at G. There are also many horse riders who live in that area and make good use of the rights of way available to them. The British Horse Society supports this proposal. The route is, there's clear evidence of a track approximating the route of alleged bridleway number 5 on Greenwood's county map, shown on 192. This route is slightly unusual. Somebody else has done a trawl of these maps and only identified maybe a dozen, at most 20 different cases where this has happened. Here you can see, if you look north of Snook Bank, you'll probably be able to make out it says Bridleway. So although this route is identified, on Greenwood's map it's not just identified generically as a route. It's specifically labelled Bridleway, which, as I say, is relatively unusual. There's certainly less than 20 examples of this kind of labelling that we're aware of across the county as a whole. On the 1866 Ordnance Survey map on page 194, you'll see there's clearly a route all the way through. But there's a general northeasterly continuation towards Glenclees, but this doesn't resemble the route of the existing bridleway number 1. So from between Snook Bank and Glenclees, there's a different routes that people had to follow in those at that time. On the 1897 Ordnance Survey map, which is on pages 195 and 196, split across two, there's clear evidence of an unenclosed track over the whole route of alleged bridleway number 5, just east of Point G. So this is at the western end of the route. It's labelled BR, or Bridleway. And just east of Point H, the continuation of this track within Newton-on-the-Moor parish, that's the second plan on 196, is also labelled BR Bridleway. On the 1923 Ordnance Survey map, which you can see on page 198, the Ordnance Survey surveyor at that time has downgraded the route. So you can see at what was Point G, sort of the top left area of the plan. It's now, where it said Bridleway in the previous edition, it now just says FP footpath. On the 1930 schedule of public rights of way identified under the Rights of Way Act 1932, basically the annex sections of the route, annex rural district sections of the route, were identified as public bridleway then. So you had Bridleway, the Edlingham Bridleway terminating at the Rothbury rural district boundary, and then the route from Glenclees heading up, the bridleway from Shield Dykes, again terminating at the Rothbury rural district boundary. There was no equivalent schedule produced for Rothbury rural district area, so we've just got the annex rural district areas to go on. But effectively, where you've now got the existing public bridleways in Edlingham and Newton-on-the-Moor, they were also identified as that in, in the 1930s. 1952 original survey of for the definitive map, there on pages 203 and 205. This gets a bit messy because the definitive map was originally prepared on a rural district council area basis. So you'll see at the bottom of the plan, the first one on page 203 is the one that was produced for Rothbury Rural District Council area, and that shows the route, the bit that we're talking about now, the Snook Bank route is coloured in purple and identified in 19, so that's purple as footpath. But if you turn over the page onto 205, you'll see that the continuations on the Annick Rural District Council area map were shown in green. That denotes Bridleway. And then if we go to page 209 for the draft map, you again got the Rothbury Rural District is shown there bit as a footpath, but on 210 you've got the Annick Rural District Council area shown with green as Bridleway. The provisional map, Rothbury is the same, showing its footpath. Annick resolutely sticking to their guns, they're showing their bit as Bridleway. On the 1957 Ordnance Survey map on page 213, again, the bit near Point G, the parish boundary, near the parish boundary is identified as FP on the Ordnance Survey map. Definitive map, original definitive map on page 214, for the Rothbury Rural District Council area, there's bits unsurprisingly shown as footpath. But on page 218, the Annick Rural District Council area, their bits are shown as Bridleway. And then the first review map on page 221, the definitive map underwent a review with the relevant date of 1st of November 1963, which would have been an opportunity to correct these kind of things, but for whatever reason, nothing was done on this route. So we're still left with the position of the Annick bit being Bridleway, and the Rothbury part is still shown as a footpath. Yeah. Then on the 1978 Ordnance Survey map on page 222, you'll see the route on the well, the Rothbury Rural District, the footpath part, disappears across the moorland altogether. Well, you can kind of see from the photographs that that's not terribly surprising because it wasn't terribly visible when I went there. Admittedly, this was a long time earlier than that, but I think it's just kind of fallen into disuse, or largely into disuse. So I don't think I need to go over the site investigation, but basically you could see that there was the obstruction at the Snookbank farm bit. These obstructions might mean that the landowner would be receptive to the diversion proposals flagged up by the Cycling UK. Doesn't mean that they have to be, and largely that's irrelevant to this process because we're looking at the evidence as to whether the rights exist or not. But it may be that there's some mileage in exploring options to divert the route onto perhaps a better line that's going to be less contentious. Armstrong's, Friars and Kerry's maps don't show the alleged bridleway route or the existing recorded bridleway continuations northwards towards Edlingham or easterly towards Glenclease. Since public footpaths don't appear to be shown on these maps at all and public bridleways only figure very occasionally, if they had been shown, this would have been some evidence in favour of the existence of higher rights. Friars and Carey's maps do both show a route between Glenclease and Snookbank, but this appears to be an entirely different one to the existing bridleway number 1, footpath number 5 route. Greenwood's map is very different, however. It does appear to show the majority of the alleged bridleway route, although, as with the other county maps, bridleways are not typically shown. There are a few instances spread across the county where bridleway routes are shown and labelled as bridleway, and this is one of those instances. Although the point G to Snookbank section of alleged bridleway number 5 has been shown on Ordnance Survey maps from 1866 to 1957, and the Snookbank to point H section has been shown on OS maps from 1897 to the present day, this can only really be taken as evidence that a path track existed on the ground. This route is already recorded as a public footpath, so the OS maps are of little help in trying to determine whether or not higher bridleway rights exist. On the 1897 map, the route is annotated BR. This reflects only the impression that the OS surveyor gained at the time of the survey. It isn't necessarily an accurate representation of the public rights that existed. On the 1923 and 1957 OS maps, the route is annotated FP, which suggested that the route was, by then, less well defined on the ground than perhaps it was previously. The survey maps produced in association with the preparation of the first definitive map of public rights of way in the early 1950s seem to be the first to indicate that the status of the GH Long Framlington section of public right of way might not be the same as the Edlingham and Newton-on-the-Moor continuations. The maps appear to have been prepared and the routes themselves surveyed on a parish area basis. Most of the public footpaths crossing from parish X to parish Y tended to be identified as public footpaths by both parishes. Most public bridleways crossing from parish X to parish Y tended to be identified as public bridleways by both parishes. But there were a few cases where a route crossing from parish X to parish Y was identified as a public footpath in one of those parishes and as a public bridleway in the other, or sometimes not as a public right-of-way at all. Whilst it's certainly not impossible for a public bridleway to stop at a parish boundary, with the continuation in the next parish being no more than a public footpath, this situation is rather unlikely. Without some plausible explanation to justify a mismatch, we would expect a route crossing a parish boundary to have a uniform status. Of course, just because parish X identify a route as a public bridleway and parish Y identified as a public footpath, we can't simply assume that it was parish Y who made the mistake. There have been a number of instances in recent years where members who've been on for a while might remember them, some of them, where the committee has been asked to consider routes which have changed from footpath to bridleway. In most of these, it hasn't been possible to determine on a balance of probabilities whether the footpath section ought to be upgraded to bridleway or the bridleway section ought to be downgraded to footpath. There simply wasn't sufficient evidence to form a proper opinion, so in those particular anomalies, those particular anomalies remained unchanged. We just had to leave them as they were. It looks nonsensical, but we just don't have enough clear evidence to point where the error was. In the case of alleged public bridleway number 5, there is more evidence available to assist us. Firstly, the existing public bridleways in the parishes of Edlingham to the north and Newton-on-the-Moor in the southeast would both be pointless cul-de-sacs if the middle Long Framlington section wasn't also a public bridleway. This isn't just a case of parish Y being at odds with parish X. Here they are also at odds with parish Z. It's 2 parishes against 1. It's by no means certain that Long Framlington parish was wrong to identify their section as a footpath and that the other 2 parishes were correct in identifying their sections as a public bridleway, but that is the more likely explanation. Secondly, on Greenwood's county map of 1828, the point G to Snook Bank section of the route was clearly identified as a bridleway. Again, on its own, this isn't proof, but it tips the scales a bit further in that direction. Finally, on the 1897 Ordnance Survey map, the route is labelled BR, but by the 1923 one, it is only labelled as FP. This suggests that a route which was once important enough to warrant special inclusion on Greenwood's map of 1828 was still evident as a significant route on the ground during the 1890s, but that use of it was declining, so that by the 1920s, it only had the appearance of being a footpath. Any bridleway rights that existed over the route wouldn't be lost just because by the 1950s most use of it was now simply pedestrian, but this decline in bridleway use might explain why those higher rights were overlooked at that time by Long Framlington parish when the definitive map was being prepared. Neither the documentary evidence nor physical features are able to assist us really in terms of width, because there isn't anything to go on. Therefore, if this route was to be included in a future definitive map modification order as a public bridleway, it's proposed to record it with the council's standard default width of 3 metres for bridleways. In light of the documentary evidence available, it appears that on a balance of probability, public bridleway rights have been shown to exist over the route of existing public footpath number 5, and it would therefore be appropriate to recognise the public's higher rights by recording it on the definitive map as a public bridleway. Officers should negotiate with landowners, occupiers and path users to see if an alternative alignment for the bridleway might be advantageous to all parties. Thank you, Chair.
Thank you, that was very interesting. I guess what you're saying, if I may ask myself, that given that horse use was the primary means of transport in the earlier days, it's highly likely that a decline in bridleway status would be the way things went.
Yeah.
Is that what you're really telling us?
Yeah, I think so. I mean, and generally, in the past, people, before motor cars, people will have tried to take the most direct route, whether on a horse or on foot. And with the advent of motor cars, it becomes quicker to use if you want to drive from Edlingham to Glantlees or anywhere else, you're just going to jump in your car and drive on the road. So the general traffic, horse traffic obviously, but just general traffic anyway will diminish over these routes, is why a lot of them, which might have been quite significant in the past, sort of fade into invisibility now.
As you found. Good. Are there any questions from members? No, you've done a good job. Thank you. And
Battered people into submission, I fear.
Yeah, well, 175 shows 2 recommendations, or recommendation in 2 parts. May I have a move of recommendations, please? Thank you. Are you moving? Is that seconded? Thank you, Collins. And those in favour? Unanimous. Wonderful. Well done. Thank you very much indeed, Alex.
Thank you.
Very thorough. Fascinating when you know the area, sort of. That's very good. I always take these away because I don't use them. I think, oh, hang on a minute. Is that it? Pardon? Yes, is there any, thank you. I'm drifting off. Is there any other urgent business? No, I declare the meeting closed. Thank you very much, Alex and officers.